SJC-13419, Michael Hanley and another, v. New England Automax, Inc., and another.
Okay, Attorney Aronson, whenever you're ready.
Good morning, Your Honors. May it please the Court. Mark Aronson, I represent the petitioner's appellants in this case. With me is Attorney William Raven. I've been referring to them in the brief as defendants, and I will continue to do so today. We submit this is an important case, not just to the parties here, but also to other litigants in the district court who have rights created by statute to have cases of a certain value heard either in the district court or the Superior Court. Now, this appeal presents two main issues. One, should this court hear this appeal on the merits pursuant to General Laws 211.3? And if so, did the district court err in denying a Rule 12b-10 motion arguing improper amount of damages? I'd like to start with the first issue. As far as I can see it, my burden is to prove a substantial claim of a violation of a substantive right, an irremediable error, i.e. error that cannot be remedied in the normal appellate process. And I'd like to start with the appellate process because that was the basis for the single justice's denial of the petition. In 2004, when General Laws 21819 was enacted, the then Chief Judge of the District Court said in a memo, denial of a Rule 12b-10 motion appears to be immune from appellate review. And that appears to be the case. This is an extraordinary situation, and I recognize 211.3 relief is extraordinary. First, there's no direct appeal. That is foreclosed, we submit, by the plain language of Section 19. Otherwise, in terms of an interlocutory appeal, there is no statute or rule that would authorize one.
Can you please address 231-108?
231-108. That is, as I understand it, the enabling statute that creates appellate division jurisdiction. It references interlocutory appeals in two ways. But before I get there, in terms of a right to an appeal, it says an aggrieved litigant shall have the right to an appeal pursuant to the rules. And what is absolutely clear is the rules only permit a conventional post-judgment appeal.
Well, sorry, can we just slow down and read the sentence because it's sort of important. Any party to a cause brought in the municipal court or of the city of Boston or in any district court aggrieved by any ruling on a matter of law by a trial court justice may, as of right, appeal the ruling for determination by the appellate division pursuant to the applicable rules of court. Do you think that that can reasonably read to say that they may appeal, aggrieved by any ruling, they may as of right appeal unless the court decides to enact rules that preclude them from appealing?
I think the answer is appellate jurisdiction is defined by the court rules. And the court rules are abundantly clear here. I would invite the court to District Court Rule 4 and compare that with Mass Rule of Appellate Procedure Rule 4. Unlike its appeals court counterpart, Rule 4 only permits a conventional post-judgment.
What about Rule 3 of the BMC and District Court rules, which specifically refers to orders as well as judgments?
I don't have Rule 3. I don't have it on the top of my head right now. But what I think Your Honor is getting at is probably a right to an interlocutory appeal pursuant to the present execution doctrine, which my friends over here rely heavily on.
Why do we have to resort to the present execution doctrine when, admittedly quite unusually, we have a statute that seems to give litigants as of right, at least where there's a question of law, a right to go to the appellate division? Why do we need to resort to the doctrine of present execution in that case? Because
the statutes conflict. The as of right incorporates the rules. The rules don't permit an interlocutory, at least that's my reading of the rule.
So you said earlier that court rules create causes of action. I thought statutes create causes of action.
Well, the statute appeals. The enabling statute here incorporates the court rules by reference. And I would also point the court, the enabling statute for the appeals court, by the way, 211A, that says the appeals court's jurisdiction is a little different. It's bound by rules and the common law principles. That's something, for example, the present execution doctrine is a common law doctrine. And I would just like to add, I have researched this extensively. I can find one case from this court that involves interlocutory appeal from the district court arguing present execution. That's Fabre. That's a 211-3 case just like this one. Then comes Van Loo, which was related, and they basically said anti-SLAPP appeals shall go to the appeals court rather than the appellate division.
Well, isn't it interesting, though, that 23197, considering the Superior Court, is very clear. It uses the word judgment. So it's very clear that when the legislature only wants to provide for a right of appeal following judgment, it can do so. And in fact, this isn't addressed in the briefs of the party, but if you look at the annotated laws, the language here we have now about, may as of right appeal the ruling, any ruling of law, it formerly, until 1975, said once it's ripe for appeal at judgment, approximately, and the legislature removed that language in 1975. So now we are faced with a situation where the district court's statute says anyone aggrieved can appeal as of right any ruling on which they're aggrieved, which is quite different from what it says for the Superior Court. And I'm curious about this question about the applicable rules of court, because I agree there's a little bit of a limitation there that pursuant to the applicable rules of court. So do you have any case law standing for the proposition that where the legislature seems to have given a right to appeal, the rules of court can take that away as opposed to just conditioning it?
Our argument is based on the plain language of the statute. It appears as though the legislature authorized the appellate division in a way to define its appellate jurisdiction by crafting rules. And what is clear, and I can't get inside the heads of the drafters of the rules, but they don't seem to authorize an interlocutory appeal. And perhaps what they were thinking is...
Well, actually, so Rule 4 is what you're heavily relying on, and that is the rule that pertains to when you file the notice of appeal. The real rule about how to appeal is in Rule 3, and that rule does say order as well as judgment.
Can I make one response to that? In a typical appeal, you are certainly appealing orders that are made along the way. You just need to wait for final judgment, and you need to establish prejudicial error under those circumstances. So perhaps that's what the drafters were getting at. But what is clear is Rule 4 plainly dictates when an appeal may be taken, and it seems to say only post-judgment. And one more point I wanted to get, I have access to appellate division rules or appellate division cases going back 5 decades. I was only able to find 2 cases in 5 decades applying the interlocutory appeal as a right under present execution. But neither court addressed the preliminary question of whether it was appropriate in the first place. And one more point on that. Appeals of 12b-10 motions, there's only been 3 of them. All 3 of them were 211-3 cases. That's Speronis, that's Langone, and then there is Toro, which was a single justice opinion by Justice Botsford. I recognize it's single justice, that's not binding.
I read the brief, unfortunately, at the last minute. What does Justice Botsford say in Toro? Why does she grant relief?
I would urge the court to read it very carefully because it is squarely on point. In fact, I'm having a hard time distinguishing it, frankly. It's a proposed class action alleging Wage Act violations. The plaintiff there said under General Laws 21819A, the district judge was bound by a statement of damages that said $10,000 in damages. Justice Botsford said, I'm going to look at the operative complaint. The plaintiffs there are asking for more than $10,000 in damages. They're asking for another $25,000 in lost wages plus attorney's fees. And she granted relief, essentially saying that the lower court...
Is that because it was patently obvious that it was above the amount, while this one is not patently above it? Right now, it's below it. It may very well grow to
Sure.
100 times the amount.
She didn't use anything to the effect of painfully obvious. I believe it was 25 plus 10 plus attorney's fees, and admittedly, at that time, the statutory threshold was
Can I ask you?
25. Sure.
If we look at the appellate division statute and then Rule 3 and Rule 4 of the district court rules and say that there's a remedy there, which means there's no 211(3) jurisdiction, or we decide there's present execution, you lose either way, right?
Well, here's the problem with present execution.
What about that question?
I'm sorry, could you repeat the question, Your Honor?
Lose both ways?
If there is no adequate remedy in the normal appellate process, I'd urge the court to hear the case, just like Justice Botsford did
Okay.
in the
all
Torah
right.
case.
Well, with all due respect,
Yes.
we're all single justices and we make our own calls. But if we have either appellate division jurisdiction through the statute plus the rules and or present execution under the common law, there is an available remedy, so no 211(3).
I agree.
Okay.
Yes.
Is there also a third way you lose, which is so right now there's only one plaintiff, and the amount is under the threshold.
It's two plaintiffs, actually.
Two plaintiffs.
Yes.
But isn't this gonna, if he starts getting a bunch of new plaintiffs with new demands, the case is gonna move to Superior Court anyway. So is this kind of like not the kind of extraordinary stuff that requires us to be doing this? This is gonna work itself out in the ordinary course of litigation?
I'm not sure if you accept the district court judge's ruling, I'm not sure it's going to make its way to Superior Court anyway.
The district court's gonna hear a 100-person class action suit with damages of a couple $1 million. Maybe if they don't shift it then, maybe we have to do something. But right now, isn't that gonna work itself out?
I think Your Honor is making my point for me as to the importance of this case and a defendant's right to have a class action in the Superior Court. But here's the problem. The district court read Section 19A as limiting the judge's analysis to the initial statement of damages. So that's what the denial of the 12B10 motion was based on. And that's not going to change if a class is certified. And that's why we're here. I think this case presents a very significant issue. And if I'm running low on time, I would urge this court, even if it does find that there's no right to 211(3) review, I'd urge this court to take this case under the second paragraph of 211(3), because we submit it is necessary to address and resolve what I see as a systemic issue that really matters to litigants in the district court. There are very different rules and processes, time standards, number of jurors, attorney-conducted voir dire, and what was eye-opening for me are the respective caseloads of district versus Superior Court judges. It's in footnotes in our brief, but something like 2,700 cases per judge in the district court. And going back to Justice Kafker's point, a case like this could present...
These are rather routine matters, with all due respect. As a Superior Court judge, we would get remand requests all the time, and we'd have to sort through the addendum and to see whether or not they were appropriate for jurisdiction. These are kind of things that district court judges and Superior Court judges do every day.
I don't know
if... And you want us to do it?
I don't know if they do 50-person class action cases every day, but I
They look at
understand.
jurisdictional amounts every day.
And the problem is the right to be in Superior Court really wouldn't matter all that much.
Where that right stems from. I get that there is a district court jurisdictional amount in controversy that's procedural according to Spironis. Why does that translate into a right to the litigant to a particular forum, either superior or district? You said that at the beginning of your argument, and I don't really understand why.
Well, first off, rights can be created by statute, and I think...
Right, but this statute says the jurisdictional limit, which we've now interpreted as procedural, is now $50K. for the district court. I don't understand why that creates a right in your client.
Oh, well, my response to that, Your Honor, I'd say that's apples and oranges, to use an expression that I've heard Justice Lowy say. Procedural versus substantive for purposes of subject matter jurisdiction, I'd submit is not on point here. In fact, I cannot find a case, and I don't think my brothers could either because I didn't see it in their brief, but explaining what is a substantial substantive right for purposes of 211.3. I see I'm out of time, but if the court will just indulge me one more sentence, it seems as though what the judges do is they look at the importance of it, and then the single justices anyway make a judgment call.
But where does your right come from?
From Section 19.
So the jurisdictional limit of the amount in controversy of the district court, in your opinion, creates a right in the litigant to a particular forum.
To have cases of a certain value heard in a certain forum. And I see I'm out of time, so unless the court has any questions, I will rest on my brief.
Okay, thank you.
Thank you.
Okay, Attorney Richardson.
Yes, Attorney Robert Richardson on behalf of plaintiffs, appellees, with Attorney Edward Cumbo. May it please the court?
Yes, please.
Sure. So
We're easy to please on that.
good. I think this is a pretty straightforward case, and we were hitting on it earlier with respect to Rule 3. So under 211.3, there must be a substantial substantive right implicated, and there must not be an alternative adequate remedy in the normal appellate process. And as we step through, we step through 218 or 231-108. It's not just limited to final judgments. It says any party aggrieved by any ruling of law has a right to appeal to the appellate division. And in fact, in that enabling statute, it talks about the appellate division being created essentially to hear questions of law. And that's exactly what occurred here. But there's two elements there, and it's substantive right, and as many justices have pointed out, this court has said that that's a procedural right. So on the first element, it fails. So 211 is not proper. 211.3 is not proper under that. But even under the second element, it's clear that there is an alternative remedy, and possibly two.
Counsel, on that point, I think that that it's fair to say that even if you're right, that 231-108 does provide a right as of right to an interlocutory appeal here, this court has on a number of occasions suggested or arguably held that 211.3 is the appropriate avenue here. Spironis is fairly clear on this point, and I think interestingly referred to the, quote, uncertainty regarding appellate rights in the district court and BMC. So are you aware of how this court has dealt with the question of, is there an alternative standard of review, or alternative avenue of review, where perhaps a litigant may have had very good reason to believe there was not an alternative avenue for review based on this court's own cases, and so sought 211.3 pursuant to all extant appellate authority about how to go about contesting this?
Sure. With respect to that case, I think if you look at kind of the background of the statute, right? Essentially, and this predates my practice, but 2004, the statute changed where essentially the legislature sought to essentially get rid of the removal remand system, right? The one trial system. And in doing that, they invested, money jurisdiction or in both the Superior Court and in the District Court. Essentially, they wanted to get rid of this, removal and remand process. And I think if you look at that case, in particular, this court, and you're the court, so but my take on it was that it was a relatively new issue. The definition, the issue there was the definition of the term plaintiff and whether that included a defendant who brought a compulsory counterclaim. And I think that's very analogous to the situation here. However, I also think that was done at that time because of the newness of the statute, and I think the court wanted some clarity on that point, that the plaintiff there's some real analysis in the Langone case about Section 104. And essentially, Section 104 was repealed, and that essentially walked through the iterations where before you could remove the case to Superior Court. In the court in Langone, this court in Langone essentially said, that's no longer the case. One of the issue presented in Langone was one of the situations under 104 where that was repealed, and the legislature specifically wanted the district court to proceed. So, and that dovetails with what Judge Coven did here in district court, and that's essentially looking at the term plaintiff at the time of the filing of the complaint. And that's the statement of damages piece to this. So I think although the court pulled it up at that point, I don't think that's the normal course. And quite frankly, as has been mentioned, I don't think this court should use its limited resources and time to review whether a defendant's not happy because we're in district court because they'd rather file 9A, motions, right? Like, I don't think that that's an appropriate use of this court's time, and I think that's gonna essentially open up, defendants to doing this, right? If we could have filed in Superior Court, we could have filed in district court. We do it based off of the information we have at the time of the filing. We haven't engaged in full discovery. We don't have, all the.
Have at least 2 clients.
We did not have 2 clients at the
No,
time.
no, at the time. But now, before you served the defendants, you actually had 2 clients. Isn't that right?
I think we filed the amended complaint after, but it was 3 months later. So, but the statement of damage was submitted in the first original complaint, and there's nothing that requires a second statement of damages.
Did the defendants submit their own estimate?
No, and they have the right to do that, and they did not do that. Now, I don't think that necessarily waives the right to raise it in an answer, because I think in one of the cases it talks about their ability to do that. But they did not dispute
Does
it.
inform our analysis of Judge Coven's decision, right? If he's looking at one set of numbers and on the other side he's got nothing.
Yeah, but they could have submitted some calculations, and they had access to
And they
data
didn't.
files, and they did not. Yeah, absolutely, absolutely. So I think that does support Judge Coven's
Can you,
decision.
I appreciate that the first sentence of 19A does refer to the statement of damages, but later 19A goes on to talk about a hearing and additional potential written submissions by the parties at that hearing. And then there's the fact that 19 refers to this entire thing is supposed to be an assessment of this action, which to me seems like you should look at the operative complaint. Can you give us your strongest argument for why the court should blind itself to literally the operative complaint when making an assessment of the damages, or is that not your position?
Well, I think it goes back to this one trial court system, right? So the district court does have concurrent jurisdiction for money damages. And at some point you have to, if you're gonna get away from this removal and remand system, you have to draw a line of where you analyze this. And I would suggest that that line is at the statement of damages and when the
Are you
complaint is
saying
filed.
that your case is going to stay in district court? Are you suggesting that this case is going to stay in district court and be heard in district court and resolved in
Yeah,
district court?
absolutely. And I will tell you this,
If you get 100, if you get 20 more plaintiffs, you think this belongs? I mean, Judge Coven wrote, there's been no class certification. He was careful. He didn't write that you get to stay indefinitely if you get 30 clients, right?
he didn't say we didn't either, so.
You think the district court's the right place for a 100-person class?
Yeah, I absolutely do. The legislature specifically,
This is an important case, and
did the legislature granted money jurisdiction. They didn't limit it to say, hey, if it's too complicated.
if you're going to be seeking $2 million or $3 million or $5 million in damages and triple attorney's fees, we're familiar with Wage Act class actions.
Sure.
They're not $50,000 cases. Are you saying that because initially this is filed as a one-person potential class action, it stays in district court?
I would suggest that under the legislature passing the one trial court system that invested money jurisdiction with the district court to hear all matters, I don't see why it wouldn't.
Under $50,000.
Unless it's reasonably likely to, unless the plaintiff's reasonably likely to recover $50,000. And that's the heart of this case. What does the term plaintiff mean? And we briefed this, and this court in Langone said essentially a compulsory counterclaim can't ruin that jurisdiction.
Are there any cases out there that have said in this context? Because maybe this does present an important legal issue that I wasn't familiar with. But are there any cases that say that in district court, before a class action is certified, that's the issue on the amount of damages, even if this could be a $1 billion cigarette case,
Right. Again, I don't think there's anything that limits that. In fact, the legislature invested concurrent jurisdiction for all cases involving money damages. We just settled the case in Quincy District Court, a class action with approximately 70 class members for just under $1 million. So I don't think that's something that's prohibited in the district court at all. In that case,
anyone challenge your jurisdiction on
no one challenged the jurisdiction in that one. And I'll.
lucky?
I think if you read the statute and you look at the analysis that Judge Coven provided and this court's ruling in Langone.
With the issue of what happens if the class is certified and the amount of damages goes over $50,000, right? He says there's been no class certification here, right?
He does say that. Yeah, but does that ruin money jurisdiction? I'm not sure what would be the grounds for that to ruin money jurisdiction because and I know what you're going to say, but if you step through it, right, and that's what Langone said. Essentially, at some point, if we're gonna implement a one trial system, what do? You go through discovery and then you say, you know what, the damages are going to go up. So now we're going to have to move it we're going to have to remove it to Superior Court. Where along that path of litigation after the complaint is filed?
Langone says, because I haven't read it in a long time. What does Langone say?
Langone essentially says the term plaintiff means the party who brings the complaint. The original complaint. And when...
Well, it doesn't say original, does it?
It says who brings the complaint.
Right, and in this case, you've got two people bringing the complaint.
Well, but in that same regard, if someone were bringing a counterclaim, that's also a complaint as well. And the court said you can't ruin jurisdiction on that in that iteration. And I think that's very similar to the situation here where you have a second plaintiff who's coming in later. And again, there's nothing that says that the court can't proceed if the parties are going to, or if the plaintiff's going to recover more than $50,000. And that's why the legislature, granted concurrent jurisdiction because they didn't want this inefficient use of judicial resources.
Right, and that really
removal of the land
places a
system.
premium on the reasonableness of the district court judge or the BMC judge's determination as to the amount in controversy, which makes this, as Justice Kafker was saying, an important case.
Sure. So here, I think that's a different issue. So if we, I don't think there's any way you can argue that 211.3, you can argue, but I think that the 231.108 is clear that provides a remedy here. That wasn't taken. Under Rule 3 and 4, I think they had 10 days to file.
Right, I guess my point was more about second paragraph of 211.3 on whether or not it makes sense for this court to analyze this very important issue of upfront determinations of amount in controversy and where the particular suit should take place. As we did in Speroni's.
This court could do that. It's what, it's you're right, obviously, but I don't think that was before presented here. I think that the question was whether there was a right to have this heard by any defendant, whether a defendant should be allowed to pursue this, 211.3 path. And I don't think that issue is anything other than no, they should not. And I think that's because there is an alternative remedy. So if there's a separate issue of whether a class action should ever be heard in a district court, I don't think that's here before the court today, and I don't.
Oh, but it is because that's the complicated issue here, which is you've brought this as a class action, but the class hasn't been certified. The amount right now is under $50,000, but you yourself envision this to be a class of many with much more at stake. So it starts to sound like this is the kind of thing we should be dealing with.
Well, again, one, we don't know that because discovery hasn't taken place yet. So they're contesting whether, they're contesting many aspects of the Rule 23.
I thought you were okay because if you actually did add people and a class, it became clear we're really doing the class, the judge would have another opportunity to say, oh, this belongs in Superior Court. But you're saying, nope, we got to do this up front. And that's what you're going to be arguing to the judge. So that makes it a little harder.
Well, again, we're not there yet, first off, but to the extent that we're, again, looking at the intent of the legislature in enacting the statute, it was to get rid of this removal and remand. So I think, with all due respect, under the scenario you're suggesting where, hey, you know what, if at some point during discovery, it looks like this may be more, then the judge can remove it. I think that just goes right back to the problem with the removal and remand system and the inefficiency. So, you know, maybe, you know, there's cases, maybe the outcome here is there are cases in district court that, you know, settle for or resolve, whether through trial or settlement, that for more than the $50,000. And I think that's okay. That's exactly why the legislature granted concurrent jurisdiction.
So isn't this like an end around the statutory amount? I mean, aren't you just, what's the point of having a statutory amount?
So again, I think the point is that reasonably likely to recover, right? So there needs to be some implementation of that standard. So in this case, if we don't add the second plaintiff, it's reasonably likely that the single plaintiff is not.
But you do add a second plaintiff.
Yeah, 3 months later. And
Yes, but that's what's going to happen. It's going to be reasonably likely to go over $50,000. What's the point? I mean, you're going around that by starting with one. If you want to stay in district court, your point, all you have to do is put in one plaintiff, put in the statement of damages, you can lowball it, and then you can have your trial in district court where it seems you're fairly successful.
Right, well, I would suggest, you know, we put in a statement of damages that reflected the facts at that time, right? That we weren't like.
No, that's fine.
Yeah.
But it ends up being a sort of a strategy to stay in district court. And so that's what people can do.
You can spin that either way, right? I mean, you know, we could have filed in Superior Court, and they would, you know, they could argue that we weren't reasonably likely to exceed $50,000. That's something we face all the time with on the plaintiff's bar. You know, you're always going to get an argument one way or the other. It doesn't matter. So to suggest that somehow we're trying to evade, you know, it's just you know.
Well, I'm only saying that because you are, right? Because you said that you shouldn't look at anything else except the initial statement.
Well, that's what the statute says. It suggests the plaintiff who brings the complaint and look at the statement of damages. It also then.
Statute doesn't say only look at the plaintiff's statement of damages.
It says look at the statement of damages.
It says look at the statement of damages, and then it also says the defendant can also submit a counter statement of damages, and then when it comes up on appeal, then it can reassess based on the entire record. So it seems to me that the interpretation that the judge below gave of just looking at the statement of damages of the plaintiff and that alone, that seems to me an improper interpretation of the statute. And maybe we use 211 Section 3, Paragraph 2 in order to correct that obvious misunderstanding because of the consequences that Justice Kafker is pointing out of being in that wrong form.
Well, even under that scenario, would not the proper path have been to go through 231 Section 108? That would have been the proper path.
That would have been the proper path.
Yeah,
yes.
which didn't occur here. So, you know, as far as we sit here today, whatever, you know, path we should have taken, I think it's clear that the path should have been 108.
That's fair.
So,
But there's another, as Justice Wendlandt just pointed out,
Sure.
we can decide it under Paragraph 2.
I just am not sure that issue is presented here with the two plaintiffs. I don't see how that's an issue. There's not a, but
It is, you've now alerted us to sort of the bigger issue, not you personally. The case has alerted us to a bigger issue, so, which is this whole question of starting class actions in district court, and because you only have one person at the time, but then the number could go staggeringly up. That presents an interesting legal issue.
and again, under the, I would suggest, I know, you know, we've gone back and forth here a little bit on this, but, you know.
Actually, we are, and we've, thank you very much.
Yeah, yeah.
We're 2 minutes over.